ng Senate na yung selyo na yung may bilog na may konting hawakan na yan, kapag itinirik na po yan sa kanyang stand, that signals the start of the impeachment trial or the session in the Senate Hall. Impunto ang 2:00 at pumuupo na po lahat ng mga senador sa kanilang mga pwesto at mukhang handang-handa po silang pakinggan ang makasaysayang pagtestimonya ng Chief Justice sa araw na ito.
Inaasahan natin, Mark, na ngayong araw ay kumpleto ang mga senator judges, 23, all of them waiting to hear what the Chief Justice has to say on the witness stand.
And we would love for them to personally see this. Let's all watch this.
Trial of the Honorable Chief Justice of the Supreme Court, Renato C. Corona, is hereby called to order. We shall be led in prayer by the distinguished senator from Batangas, Senator Ralph G. Recto.
We seek your blessing, O Lord. So today, we will only hear the facts, not the fable, the truth, not the trickery, the authentic, not the alibis. We ask you, Heavenly Father, to enlighten those who will speak here today, so they will impress us with their honesty and not indulge us with their evasion, gain our respect with their candor and not lose it through their excuses, clarify our doubts instead of adding to our confusion. We beseech you, dear God, to guide those who sit in judgment today, so we will be curious without being caustic, be inquisitive without being insulting, be probing without being hurtful. We plead to you, our Master, to grant the bigger jury out there the wisdom so they will be able to witness the proceedings with kindness in their hearts and fairness on their minds, to erase their biases and embrace a thought that judgment should be put on hold until the accused has been heard, to know the important from the immaterial, to discern the substantial from the subterfuge. Guide us as we search for the truth, and when, with your grace, we find it, then be assured that the truth shall not make us mad, the truth shall not make us miserable, and that the truth shall set us free. Amen.
Amen. The Secretary now please call the roll.
Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President.
With all the senators, 23 of them, senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the May 16, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the May 16, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Majority Floor Leader. The Secretary will now please call the case before the Senate as an impeachment court.
Case number 002-2011 in the matter of impeachment of Honorable Chief Justice Renato C. Corona.
Majority Floor Leader.
May we ask the parties and or their respective counsel to enter their appearances for the prosecution, Mr. President.
Good afternoon, Mr. Senate President and honorable members of the Senate. On the part of the House of Representatives prosecution panel, same appearance. We are ready, Your Honor.
Noted. Defense.
For the defense, Your Honor, we have the same appearance and we are ready, Your Honor.
Noted. Majority Floor Leader.
Mr. President, before we proceed to the business of the day, last week, in connection with the testimony of Ombudsman Conchita Carpio Morales, some members of the court had requested to subpoena the managers of the banks concerned, as well as certain bank of or fund documents mentioned by the Ombudsman in the course of her testimony. I move that the presiding officer rule on the request, Mr. President.
Thank you. The Chair is well aware of the validity and importance of the motions made in that connection. However, I would like to remind all of us, members of the Senate sitting here, to perform a function to judge the respondent, that we are not conducting this inquiry in aid of legislation. We are here as hearers of facts. And in the course of our trial and judgment, we will interpret the law according to our best lights. We are receivers of the evidence from the prosecution and the defense. We are not an inquisitorial court. And so therefore, with that in mind, this court cannot issue the subpoena suggested to make the appearance here of certain persons to act as witnesses. Our rules of procedure suggest that this is an adversarial proceeding, although done by the representatives of the people, and so therefore we must define for whom will the witnesses that will appear here will stand as witnesses. Are they going to stand as witnesses for the prosecution? Are they going to stand as witnesses for the defense? Are we authorized as hearers of fact and receivers of evidence to call anyone we want to testify here to enlighten us on certain factual issues? Having this in mind, this chair has decided to resolve to respectfully deny the motions to call for this Senate, sitting as an impeachment court, to call witnesses motu proprio to testify in this proceeding. So ordered.
Mr. President.
Majority Floor Leader.
Mr. President, pursuant to the May 16, 2012 order of the court for Mr. Harvey K. to submit a written explanation within 48 hours why he should not be cited for contempt, Mr. K. filed with the court his compliance on May 18, 2012, expressing his apology and praying that he not be cited in contempt. I move that the presiding officer rule on the matter.
Well, during our trials of this case last week, Mr. Harvey K. appeared here as a witness for the defense. And this chair, because of certain previous incident, asked him to show cause why he should not be cited for contempt. A member of this court had spoken, calling the concerned witness that he committed certain improper conduct as far as this court was concerned. Given that, and in view of the apologies given by the gentleman cited to show cause, and in the spirit of liberality, this court simply admonishes the person concerned never to try his luck again, as he did. So ordered. Is that the floor, Leader?
Mr. President, the court is now ready for the continuation of the presentation of evidence by the defense.
Is the defense ready to present?
May we request for
Next
a
witness.
1 minute recess, Your Honor? We are purging the Chief Justice, Your Honor.
Session suspended for 1 minute.
Pansamantala pong sinuspindi ang paglilitis habang inaantabayanan po ang pagdating ng punong maestrado Chief Justice Renato Corona sa loob ng Senate Session Hall. Siya po ay sinusundo mula dito sa holding room sa Senado.
Justice is awaited to this hall. I would like to make some statements before we administer the oath to him as a witness for the defense. As agreed during our caucus yesterday, the members of the court are respectfully requested by this chair to observe the 2-minute rule as provided under the rules of this court, to limit their inquiries to questions of facts, to avoid any manifestations or discussions of purely legal issues, and to help in an orderly proceedings in this trial. Should any member of this court require more time to propound questions later on, an extension of not more than 2 minutes will be allowed to him or to her. However, for an orderly proceeding, so that there will be no interruption in the testimony of the distinguished respondent who will appear before us, I would suggest that we finish with the direct examination by the defense, with the cross-examination of the prosecution, and then if there is any redirect, let the redirect be done, and if there is any recross, let the recross be completed before any member of this Senate sitting as an impeachment court will propound questions to the distinguished respondent acting as a witness. Unless I am disauthorized by this court, I would like to adopt that as the system for an orderly proceeding in this trial today and thereafter. So ordered. Now, is the respondent ready?
We send somebody, Your Honor, to have him page.
Okay. We suspend the session for a few moments to wait for him.
Pansamantala na namang sinuspinde ang paglilitis habang inaantabayanan pa rin ang pagpasok sa loob ng Senate Session Hall ng punong maestrado bago yan ang inanunsyo ni Senate President Juan Ponce Enrile ang ilan sa mga napagkasunduan sa caucus na isinagawa ng mga senator judges kanina. Ilan dito ay ang paglimita ng mga tanong within the 2-minute time na allotted para sa mga senator judges ang pag-iwas sa pag-extend dito. Pero kung kinakailangan ay bibigyan sila na hanggang sa 2 minutes lamang na extension.
At nilinaw din na dapat questions involving facts lamang at para siguro maiwasan ang argumento at kung anumang hindi magandang exchange with this distinguished witness.
At pinakiusapan din
in this trial.
ng
Avoid any expression of your approval or disapproval about anything that's happening in this court. No clapping, no shouting, no unnecessary commotions. Otherwise, this court, and I must be frank with you, will exercise its powers to maintain order in this trial. This is a trial authorized by the Constitution, authorized by the Filipino people. You authorized this trial, and it must be conducted in an orderly manner, without any disruption, befitting the nature of this case and the person involved in these proceedings. So ordered. Is the defense ready?
He's coming, Your Honor. He's around already.
Nag-request siya ng chair.
Mr. Chief Justice, Mr. Chief Justice, welcome to this court. And
Good afternoon po.
may I request you to take your oath before we proceed with the trial.
Mr. President,
Majority Floor Leader. Yes?
Mr. President, the prosecution.
The gentleman from the prosecution.
The prosecution would like to ask permission from this honorable court to allow one of our private lawyers, Attorney Mario Bautista, to receive the testimony of the Chief Justice and to conduct cross-examination.
Granted.
Thank you. Thank you, Your Honor.
Your Honor, please, before we proceed with the taking of the testimony of the Honorable Chief Justice, Your Honor, may I be permitted to place on record some pertinent matters in connection with his previous actuation in connection with his appearance before this court, Your Honor. Now,
proceed.
There never was a time when it was the intention of the Chief Justice not to appear before this court, Your Honor. But an examination of the constitutional provision on the matter, together with the rules of evidence, Your Honor, had in one way or another strengthened his resolve in the first place not to appear before this court, Your Honor, not in order to defy the majesty and the authority of this court, Your Honor, but rather to enable him to exercise his right as a citizen of the Republic of the Philippines pursuant to Article 3, Section 17, Your Honor, which provides no person may be compelled to testify against himself. It is his humble opinion during our discussion that this provision applies to all kinds of proceedings, whether criminal, civil, quasi-judicial, or administrative, Your Honor. And that is governed by the various jurisprudence on the point. Secondly, it is his contention, it is his belief that insofar as his cross-examination is concerned, Your Honor, the rules of evidence say, being likened to that of an accused, he may only be cross-examined on any matter taken up on the direct. Thirdly, Your Honor, he had monitored all the proceedings day by day before this court, Your Honor. And he was a little bit frightened, or shall we say, confused, Your Honor, because there were several occasions that there were statements to the effect that these proceedings will be judged not only by this impeachment court, but likewise by the people in general. I have told him that there were many instances, Your Honor, where the Supreme Court, where this impeachment court, Your Honor, through the Honorable Presiding Judge or Senator, has stated that the decision in this case shall be based on the evidence on record, and there is no power nor any person can dictate upon this court in order to render an impartial and correct decision. Now, that was too encouraging in his favor, and I told him that even the rules of the impeachment court appear to warrant this impartiality. For instance, under Rule 3, Paragraph 3, it says, senators shall observe political neutrality during the course of the impeachment trial. Political neutrality shall be defined as exercise of public official duty without unfair discrimination and regardless of party affiliation or preference. This is rather assuring, Your Honor, and consoling to the Chief Justice, because he believes that with the observance of this rule, there will certainly be an impartial decision that will come up after the trial in this case. Now, secondly, Your Honor, I have examined the oath of office of the senator judges, which states, I solemnly swear that in all things appertaining to the trial of the impeachment now pending before this court, I will do impartial justice according to the Constitution and to the law of the Philippines. That practically negates, Your Honor, whatever misapprehension he has. That's why I have chosen to appear, brought about by the respect of this impeachment court, Your Honor, and to render himself submissive to the power and authority and jurisdiction of the Honorable Impeachment Court. Thank you, Your Honor, for the opportunity.
Thank you for reminding the members of this impeachment court about these principles, and I would like, as the chair of this court, to assure you that we are conscious from the very start of this proceeding that we are performing a solemn and sacred duty, not for ourselves, but for the Filipino people and for this country and for the world to see that this country, through its elected senators, can render impartial justice to anyone who will appear here to answer any charge made against him or her. Now, we are all lawyers. The Chief Justice is the highest magistrate of the land, the highest lawyer in the country. He's aware of the Constitution, very well grounded on the Constitution. He knows when to answer a question and when not to answer a question in order to protect his own personal interest and his rights under the Constitution. So we can assure you that we will observe this. Now, insofar as judging this case is concerned, as I've said at the start of this proceeding, in my opening statement, we will judge this case on the basis of the evidence presented to us by the prosecution as well as by the defense. And that no one of us here, including this chair, will attempt to influence the mind of any of these 23 souls acting as judges in this impeachment trial, not only because we want to comply with our oath as judges in this case, but because of our notion that we respect each other's judgment. Each one of us is entity unto himself. In this case, and he alone will be responsible for his judgment in this case, and no one else, so that each one of us will respect each other by not trying to influence the judgment of each one or any one of us. So I can assure you, Mr. Counsel, that we are well aware of the things that you are concerned about. And so with that, let's proceed with the trial. So,
Thank you, Your Honor, for that very assuring pronouncement, Your Honor.
Mr. President, from the prosecution, please, may I be allowed to say something?
yes, proceed. Granted.
Good afternoon, Mr. President. Good afternoon, Senator, Justices. Chief Justice, good afternoon, sir. I would just like to make several points on what was mentioned by Justice Cuevas. There has been never any compulsion for the Chief Justice to testify. So your mention of the constitutional right against being compelled to testify is irrelevant. In fact, if you will recall, the prosecution subpoenaed the Chief Justice, and the Honorable Court denied the subpoena. Secondly, with due respect, Justice Cuevas, I disagree with the reading of the rules of evidence regarding cross-examination of accused. Under Rule 115, Section 1D, an accused can testify voluntarily on his behalf, as the Chief Justice is doing today, but he is subject to cross-examination. Under the case of People v. Aison, GR 85212, July 7, 1989, and the Diana v. People, GR number 144293, December 4, 2002, an accused who testifies will be treated as an ordinary witness. He can invoke his self-incrimination right only regarding questions that tend to incriminate him for some crime other than that he is charged of. And with respect to the rights of the Chief Justice on self-incrimination, we will raise our objections at the appropriate time. Thank you, Mr. President.
Thank you. Are you ready to proceed with
Yes,
the trial?
Your Honor. Only 1 minute, Your Honor. Only 1 minute.
Granted.
Just, Your Honor, please. I never stated in my manifestation that the Chief Justice is being compelled to testify against his will. What I mentioned, Your Honor, and placed on record is the constitutional provision on the matter. Under Article 3, Section 17, which provides no person may be compelled to testify against himself. I stated that to show, or to show to the Honorable Court his vacillation during the early stage of the proceedings, Your Honor. That was the only purpose. Now, in connection with the coverage of the cross-examination, I dare to dispute the manifestation of the matter by the learned counsel insofar as cross-examination of an accused in a criminal case, to which respondent, Honorable Chief Justice is concerned, his cross-examination shall be limited only to matters taken up in the direct. That is the amendment.
May I suggest that we proceed with the trial,
Yeah,
and we will deal with these problems along the way. That's why you have a presiding officer in this proceedings.
Yes, Your Honor. I am through with, I only place on
Yeah.
my reply, Your Honor.
All right. Are we ready with the trial?
We are,
May I be request, Mr. Presiding Officer, to make a statement not only to this honorable tribunal but to the Filipino people.
Granted. Proceed, Mr. Chief Justice.
Mga minamahal kong kababayan, ako po ay nandito sa impeachment court na ito upang tumupad sa aking pangako sa sambayanan na ako ay magpapaliwanag ng lahat. Kailangan po sigurong tanungin ng ating sambayanan kung bakit ba tayo nagkaka-impeachment trial na ito. Hindi naman po kaila sa ating lahat na ginamit na po ng gobyerno, ng administrasyon, ang buong makinarya ng gobyerno laban sa akin. Ibinuhos na po ang buong puwersa ng pamahalaan para lamang sa pagtanggal ng isang tao. Bakit po ba nangyayari ito? Huwag tayong maniwala na itong impeachment trial na ito ay laban sa katiwalian. Dahil kung ganun rin lamang, mayroon ba silang katiwalian na ibinintang sa akin? Sa kabila ng lahat ng pagkakalkal, paghahanap ng mga huwad na ebidensya, at kung ano-ano pang ginawa sa akin at sa aking pamilya, wala naman pong ibinibintang sa akin ng katiwalian. Ako po ba ay hadlang? Ako po ba ay sagabal sa kung ano o kung kanino? O dili kaya'y tinik sa lalamunan ng ninuman? So far po, lahat ng nakita ko rito, magbuhat nag-umpisa itong impeachment trial na ito, ay hatred, galit sa isang tao, benggansa sa isang tao.